Hi there. So I'm going to preface this video by saying that this is the first video that I've done, and I intend to do ones with better production value than this one. But I've been getting a lot of questions ever since I set up the TikTok channel about relocations. And I'm sorry, but I can't do a TikTok on relocations because TikTok videos are like a minute or less, and there's just no way to address relocations, or as we often call them in family law, moveaways. And you'll probably hear me refer to it more like that because that's what we always call them in family law, is moveaways. You can't talk about it in a minute because the analysis for it is much more complicated than a lot of other issues that come up in family law. But that doesn't mean this should be very long. It's just not something I can squeeze into a 1 minute long TikTok. So anytime someone asks me about relocations, I can sort of refer them to this video and be like, well, watch this because these are the factors that are going to be most important. So number one, you're going to need to ask yourself this question because it really determines the analysis that the court is going to make. First of all, the first question is this the first determination about the children's best interests in terms of physical custody and primary physical custody? Sorry, that's my phone going off. So that's the first question you got to ask yourself, because there's the answer to that question determines what the rule is that's going to apply. And by the way, these are the laws in California. Other states have similar rules, so these are good guidelines to use. But definitely in your own state, you should consult your own law in that state. And I'll give citations to the laws here in California. But like I said, that they're similar state to state. These rules oftentimes are very similar because the states, when a case first comes up in any given state, the court there usually looks to what the other states are doing for guidance as to what they should do. And California itself, as far as family law goes, is considered one of the pioneers. California and New York especially are two states that the rest of the country very often looks to for adopting rules for family law issues that come up, especially new issues. So as for getting back to moveaways, that first question about is this an initial determination? If it is an initial determination, meaning that this is the first time that the court is going to address the issue of who has custody of the children, then you're looking at a best interests determination about child custody and where the children will live. And you're going to apply a bunch of legal factors that we refer to here in California as the La Musga factors. And I'll go over each of those factors very shortly. But the first thing you should know is whether or not this is the first time the court's going to make a determination as to custody. If it is, then it is going to be a best interest determination that's guided by those factors. And we'll talk about what those factors are. If it's not, and custody has been determined, then there's an additional question you have to ask. Is it joint physical custody or is it sole physical custody to one parent? If it's joint physical custody, meaning that both parents have custody of the children and they have fairly equitable parenting time, then you're going to be doing the same analysis as if it was an initial custody determination. In other words, it's going to be a best interest analysis that is guided by those La Musga factors that we're about to talk about. If custody has been determined and one parent has sole physical custody of the children, then the best interest determination, the La Musga factors, don't apply. And instead, what you're applying, the burden in those cases shifts to the parent that is fighting the relocation. In other words, the typically in those cases, of course, it's the parent that already has sole physical custody that's moving. The other parent who wants to fight it, the burden actually shifts to them. The parent that's moving no longer has a burden. The parent that wants to fight the move away has the burden, and their burden is to show the court that it would actually be detrimental to the child's well-being for the move away to be granted. That's a pretty big burden for a non-custodial parent to meet, and that is why the law essentially says that a parent that has sole custody of the child is presumed to be permitted to go ahead and relocate with that child. So if you already have sole custody of your child and more than, say, 75% parenting time, and you're in California, your move away is almost assuredly going to be granted, unless the other parent can show that it would be detrimental. And there's some ways to do that in terms of proof of, for instance, the custodial parent being very difficult to work with and doing whatever they can to alienate the child from the parent who doesn't have that much time. So but it is their burden to show it, that there is that detriment. So setting that aside for now that you've answered those questions, and I've given you sort of the law when it comes to the case where you have sole custody, where one parent has sole custody. So really, the more complicated analysis is one of those other two cases where either there's been no initial determination as to custody or visitation, or there's been an initial determination as to custody or visitation, and that determination has been that there's joint custody. So you both have, it could be 50-50, it could be 60-40, but you still have joint physical custody. So at that case, the burden is on both of you. If the burden is on anyone, it's probably on the person that wants to relocate, although they don't really phrase it that way as it being that person's burden. But it is their motion. It is their request. I want to move away with the child. So obviously the burden falls on the moving party to meet that standard. And so what is that standard? It's a best interest standard, but it's a best interest standard that is, I guess you could say, illuminated or elucidated by what we call the Musga factors. And those factors, and here's the citation for Musga, and sometimes judges call this La Musga, and that's okay because who knows? But the citation is right up here. If you want to look up the case, just put in the case information. If you Google it, Musga was a very famous case. Those words get thrown out all the time. Musga. So you'll find more than you ever wanted to know by Googling Musga factors. If you just Google those words, you will get more blog posts than you can shake a stick at. And I suggest that you do that before going down that path. But let's go over those factors here just to address them. So number one is the reason for the move. And that's what the court wants to know. So why are you moving? Typical reasons are new job. I oftentimes get clients whose is living in a place where they don't have a lot of support. They moved here maybe for the other parent, but they themselves don't have a support system here. They don't have family or friends that can help them with the kids. They and their family back somewhere else is very supportive, and they'd like to be closer to their family. That's a very common reason. Sometimes it's just a change of scenery. I vacationed there and I loved it, and that's where I want to live. I've gotten a few cases where somebody was remarried and their spouse is from that place, or I even had a case in one case where they married a Marine, and the Marine husband, the non-parent in that case, he was a Marine, and he got, of course, as happens when you're in the military, he got restationed to another base far away. So the mom who was married to him wanted permission to move away. So that was her motion before the court. So there's a whole host of factors, but my best advice there is just, it needs to be a good faith reason, and you have to have a good reason. You can't just say, I just felt like it. That it's not going to get you very far. So you need to have a really good reason for why you want to move away. And the one reason that it cannot be that you want to get away from the other parent. That'll be an automatic sabotage of anything that you're trying to do. Even if you have very good reasons for trying to get away from that parent, that you basically just created a textbook reason for the judge to deny your request. So number two is the children's interest in stability and continuity in the custodial arrangement. So that's kind of a broad phrase, but it's very specific in terms of, if and this is actually a good place to specify something about the law that's very confusing to people sometimes. When you go to court to request a move away, you are not asking the court to give you permission to move. Court can't stop you from going wherever you want. You can move to Hawaii. You can move to Europe. You can move to Africa. You can move wherever you want to move. The question the court is answering is, can you take the kids with you? And that's the only thing the court has jurisdiction to decide. And so really what the court is ultimately deciding, and this factor is the one that you might be able to argue is the most important. The question the court has to ask itself is whether the children would be better off with you where you're going, because the court has to assume you're going because they can't tell you you can't go, or better off with the other parent here. And oftentimes that's what guides the court's decision, because the court knows they don't want to give the children to the parent, the staying parent, or they certainly don't want to give them primary custody. And so they realize, and this factor is the one that that plays a big role in that. This interest in continuity and stability is really important. And so that would if there's one parent who does all of the schoolwork and school registration and sports and athletics and piano lessons and ballet lessons and all that stuff with the kids, you want to have that continuity for them. And that may mean that the parent who does those things, that's who the children are going to be with, regardless of which side of the case that is. The distance of the move, of course, that's a huge deal. Is it a move away? There's no mileage in the law about what constitutes a move away. I usually tell my clients that what qualifies as a move away is a move that is going to, in and of itself, drastically change the finer points of the parenting plan. So, or actually more like the broader strokes of the parenting plan. So, if you're moving from one town to the next town, you could probably still get the kids to school on time. You could still do all the same exchanges that you're already doing. That's not really a move away. You might have to give notice to the other parent that you're moving. That might be in your family court order, but that doesn't necessarily mean that you have to file for a move away to do that. However, if you're moving 50 miles away, that's pretty far. If the kids are going to stay in the same school, then that would be a lot of travel for them to go to school. And if they're going to have to change schools, well, there you go. I mean, if you're moving so far that the kids have to change schools, that should be a telltale sign that it's a move away. Obviously, if you're moving to, across state lines, unless you literally live on the state line, but across state lines, across an entire state, so it's common sense what constitutes a move away. If it's going to change things in terms of your parenting plan, then it pretty much is a move away. And the distance is something the court has to consider, because a move away to, here in Northern California, a move away to Los Angeles in Southern California is a lot different than a move away to New York City. The impact on the other parent's ability to see the children is going to be very different. And so the court's going to consider those differences. The age of the children, that's a huge deal. And that factors in ways that other things don't. One of the hardest things is move aways with really young children. Because if you have a 1-year-old and you're moving somewhere that you're pretty much going to have to get a flight to do the exchanges, going from, say, again, California to New York, you can't put a 1-year-old on a plane by himself. You're going to have to go with him, or the other parent is going to have to travel. And they have to travel twice. So you have to go from New York to, say, San Francisco, and then back to New York while your child is in San Francisco, and then come back to San Francisco to get your child, and then go back to New York. or there might be some formulation of that has to happen, and that's a lot. It's a lot of money. It's a lot of time. It's a lot of travel for a 1-year-old. So that's a big deal. Whereas you might have a 13-year-old or a 14-year-old who can fly unaccompanied minor. You hand your kid to the gate agent, and they put a little sticker on their chest, and you pay an extra $75 for their ticket, and they go by themselves, and that's pretty easy peasy to do, and so that's not. It's a much different calculation that the court has to make before deciding whether to grant a request to move away for a 14-year-old kid versus a 1 or 2 or even 5-year-old kid. It's just a different dynamic. The children's relationship with both parents. I mean, I think that one should be obvious. Obviously, the more bonded a child is to one parent, the court's probably going to want to keep that kid with that parent. But also, one thing I see courts have a lot of concern over is that one parent may not be so well bonded to the child, and the court is a little troubled by that, because if you have a child that's not very well bonded to one parent, and the custodial parent is now going to move that child far away, well, now they're never going to form that bond. It's almost impossible. I mean, yes, that parent's going to see the child, and they're going to FaceTime or Skype or whatever, but it's not going to be the same. It's not the same as if they could see them just any old time or every weekend or something like that. So that's another concern for the court. The relationship between the parents, including but not limited to, I love legal jargon, including but not limited to, their ability to communicate and cooperate effectively, and their willingness to put the interests of the children above their individual interests. So this comes down to communications and good faith. So how well do you work with the other parent? And I know a lot of parents are like, I work great with the other parent. It's all their fault. They're the ones that are always wrong, and I'm always right. And if they would just agree with me all the time, we wouldn't have issues. The court's probably not going to see it that way. Remember, the judge is neutral. They don't believe you. They don't believe them. So they're going to just decide, down the middle and use the evidence in front of them to make those decisions. So it's going to be much easier for you if you have a positive relationship with the other parent. If you do happen to have a negative relationship with the other parent, make sure that it is really all their fault. In other words, you should be able to show that all the communications on your side are really good, that you're very positive with the other parent, and you're very good at telling the other parent about doctor's appointments, dentist appointments, soccer games, therapy appointments, whatever. You are proactive in terms of communicating with the other parent about those things. And if you're not, then that might be a reason why the move away is rejected. Whereas you could show the other parent is really lousy at those things. The other parent will take the kid to the dentist and not even tell you about it. Or the other parent will pick up materials from the school that are really important for the kid, and then you get the kid and don't even realize they have an assignment due because the other parent didn't tell you. So you want to be able to demonstrate the differences in those communications to the court. You want to be on the side that is really good at communicating to the other parent about everything that's going on with the child. The more you can show that, the easier your move away request is going to be. The wishes of the children, if they're mature enough for such an inquiry to be appropriate. So that's, that just depends on how old your child is. And there's no age rule under this analysis. In California, we have a law that says that a child between the age of 8 and 14, the court can take their opinion into consideration, their preference into consideration when deciding who to grant custody of that child. And then once a child reaches the age of 14, then the court has to take their preference into consideration. It doesn't mean they have to do what they want. That's a real confusion I get from clients all the time, especially here, here in California, where that's the law, and other states may have different ages, but probably similar structure, but check with your state's laws regarding that. But I get a lot of clients here who hear about the law in California, and or hear about it from a friend who heard about it from a friend, and their interpretation of that law is, well, once a kid reaches 14, the court's got to do what they want. That's not what the law says. The law says that the court has to take it into consideration, and then put into the record why they decided what they decided. So a judge, and I've had this happen in the case, where I had a 14-year-old child where the judge said, I listened to your preference. I have considered it. I've considered it greatly. In fact, in this case, the judge actually brought the kid back into chambers with the court reporter and the attorneys, and the judge asked the questions of the child, but determined that the child was being alienated from the other parent and made a different decision than what the child would have wanted. So they don't ever have to do what a child wants, no matter how old they are. But after the age of 14, they have to take it into consideration. And between ages of 8 and 14, they can take it into consideration. And I'll be honest with you, if a child is well-spoken enough to articulate to a judge or the mediator that might talk to them before they go, instead of a judge, the judge is going to take it into consideration. Almost every judge is going to take that, especially if they're going to go against their wishes. Then they'll definitely put it in the record that I listened to little Alex, and I heard what he said, and here's why I'm not going to do that. Because the judge always wants the children to feel like they were heard, even if they don't agree with them. But that's a huge deal in a move away. Obviously, if the child wants to go with the parent that's leaving, that's a big deal. Or the child doesn't want to go and wants to stay. That's going to be a huge deal in your case. The reasons for the proposed move, and the extent to which the parents currently are sharing custody. So again, that goes to that question I asked before as to just how equal. You might have a joint custody arrangement, some kind of arrangement that says you have joint custody. But I've seen joint custody arrangements where it says they have joint physical custody, but one parent has the child 80% of the time, the other parent has the child 20% of the time. And there is case law to say that the judges in those cases will oftentimes consider that to be a sole custody situation. In other words, yeah, it says here joint custody, but that's not what you're really exercising. So for the purposes of a move away, I'm just going to consider you to be a sole custodian because you have the kid 80% or more of the time. So those are the Musga factors for a move away. And I would encourage you to review them and really look at how your case fits into those factors. There are some other things that the court looks at. There's another case called Marriage of Burgess, and the citation is right here as well. And I encourage you to go ahead and look at Marriage of Burgess and see, and as well as Musga, to see how similar the facts are to your case. But there's some other factors that the court mentions in there. And because Burgess came out before Musga, and so before Musga, Burgess was the case that we all went by. But some of the factors in there are a child's community ties, the child's health and educational needs, and the child's circle of friends. So these are more child-focused inquiries for the court to make. And so these are guideposts for the court to use to make a decision about where the child's ultimately going to live in a move away case. Move aways, just to conclude here and wrap up, they're one of the most, if not the most difficult cases I ever do. I don't know any attorney that really enjoys doing a move away. You're either on the side of a parent that is going to take a child a great distance away from the other parent, or you're on the side of a case where you're fighting that. And I've been on both sides of that case, and neither brings a typical family law attorney any joy, even when you win them. Because even if you win, even if you're fighting a move away, it's really, unless it's a real bad faith move away. And that's one last point I'm going to make. So, one thing that will sabotage any move away case is bad faith. Okay, what is bad faith? Anytime that it looks like your request to move away is an effort to take the child further away from the other parent, that is considered a bad faith move away. In other words, you realize that you can get your way a lot easier regarding the child and his wishes and his needs if you can just get him farther away from the other parent. That's considered a bad faith move away. That's not up to you. That's not for you to decide. That's for you and the other parent to decide jointly. And if you can't come to an agreement, it's for the court to decide. But to the extent the court perceives you to be making those decisions unilaterally, they will learn you something. They will punish you by denying any motion for a move away because they think you're doing it in bad faith. And that's especially relevant in those cases where you already have sole custody. The way to defeat, the way for a parent who has that burden of showing that it would be detrimental for the child to be allowed to move away, which is a huge burden. But the one thing that'll help is to show bad faith. And how do you do that? Well, oftentimes, if you can get communications, text messages, emails, or witnesses to communications from the other the other parent saying that, yeah, I really just want to move him to Tallahassee so I can get him away from his father. Not good. Don't let those words ever come out of your mouth. I've had clients say it to me, and I always say the same thing. It's okay that you say it to me because I'm your lawyer, and I'm not going to repeat that. You cannot say that to anybody else because everybody will be called to testify. All your family members, all your friends, they'll all be called to testify, and they'll all be asked, did you ever talk to mom about why she wanted to move away? Yes. What did she say was her reasons to move away? Oh, well, she said dad's a scumbag, and she can't wait to get the kid as far away from him as possible. Not good. Not good. That will torpedo your case. Your case will be dead on your request for move away will be dead on arrival. So I highly, highly suggest that before you ever consider a move away, ask yourself, what is the reason I want to move away? If it has anything to do with taking your child away from the other parent, reassess. Think about it again. And that's it. So I hope that was helpful. I hope that was informative. As you can see, taking this time to explain all of this, there's no way I could have done this in a short TikTok video. And that's one of the reasons I made this other channel, to provide this information. This is my first video, so I'm sorry. I know the production value was low. I'm going to work on it and practice and hopefully improve it a little bit. And but in the meantime, I hope it was informative and educational. And please leave any feedback. Subscribe. There's going to be more videos. I promise. Just hit the little subscribe button and like it. And when I got more videos and you need more information, they'll be there. And feel free to share this with anybody who could use it. Until then, thanks a lot.